Mr. Benyon, what is double sale of land?
This matter, so it's as the name suggests, selling land to more than one person or multiple sale of lands to more than one person, and this is also an offense. Actually, it is an offense as part of what we call the prohibited offenses, the prohibited transactions concerning land. And it has its provenance from the now repealed Land Registry Act of 1962. Section 34 of that act made it an offense for a person to knowingly alienate or sell a piece of land over which he had no authority or capacity to sell, or sell land which he knowingly has already sold to another person. So it is actually fraud, and it was an offense under Section 34 of the repealed Act. Now, the Land Act has reproduced Section 34 of the Land Registry Act in Section 277 of the Land Act, which is in pari materia with the previous provision. So yes, double sale of lands is also an offense.
Normally, when an owner of land sells the land multiple times, the story normally tends to be that the purchasers of the land or lessees of the land end up fighting each other rather than turning on the owner of the land. As a lawyer with experience in land litigation, what should be the most appropriate step of a purchaser who is victim of double sale of land, or even the purchasers of double sale of land?
There is an entire corpus of authorities on this matter. The first principle being the principle of caveat emptor. A buyer must always necessarily beware. So, if you as a prospective purchaser of a movable estate are planning to make a move, the first thing you should do is to conduct the necessary checks. I am sure that a reasonably diligent proprietor of land would first and foremost attempt to register his interest in the land with the Lands Commission. So the first point of call for any bona fide purchaser of land is to make the appropriate searches at the Lands Commission. If you do not find anything there, then the second thing to do is to carry out physical inspection on the land to see if you find any physical features like a wall, like a structure, economic crops, boundary, land boundary pillars, anything that would give you actual notice or even constructive notice that there is the possibility of the presence of somebody who may put up an adverse interest to your own. And indeed, the Supreme Court has said several times, in case I'm not here to recite a number of cases, but there are litany of them, where the Supreme Court has said that for a person to be able to rely on the plea of a bona fide purchaser of land, you must first and foremost carry out these due diligence requirements. So sometimes, yes, we may have sympathy for two people who end up fighting themselves as victims of fraudulent sale in land or fraudulent transactions in land. But then you go inside, you realize that one of the people fighting is not really that innocent.
So, in this instance, where now the activity of double sale is criminalized, what should be the step from the point of view of a legal practitioner? What should be the step of a purchaser who is falling victim?
Well, the law is there. It is a crime simpliciter. So if you are a victim of a fraudulent sale in land, the first thing you should do is to report to the police station, have the criminal arrested and prosecuted. But of course, the Act also states that the prosecution of a person for any of the prohibited conducts are without prejudice to whatever rights they may have or that may have accrued to him under civil law. So he also has the option of going to court to claim for a refund of whatever monies may have been paid to the criminal. That is only if they will be available to be recovered.